it's a virtual meeting, so you can all hear me, but I don't know any one of you, neither I can see your image. If you have problem with my microphone or whatever, please stop me and interfere with me. If there are certain things you don't understand, I'm more than welcome to discuss with you. My presentation, according to Sami, should be focused on two topics: the disclosure package for the pre-construction purchase and the status certificate. Why they are approximately they linked each other, because the document you will find in the pre-construction package, most of them you will find in the status certificate as well. So when your client, with regard to the disclosure package, what you are going to find, okay? It is made up, okay. This is the disclosure package. When your client wants to buy in pre-construction, these are the documents that your client will be provided with. So there is a list. Is a disclosure statement, which is made up. There is a declaration. Here, number 2, we have the agreement of purchase and sale. Then you have a schedule 1, the declaration, the corporation, the bylaws, number 1, number 2, number 3, number 4, number 5, the proposed rules of the corporation, and the proposed management agreement. You will have the corporation proposed insurance trust agreement, and you will have the summary of the first year operating budget. And then you will have the warning that the clause for the purchase, the right to rescind. Then you will have the plan of the condominium and the definition of standard unit. All this plus the agreement of purchase and sale. So this is the full package you will provide, the builders will provide your client with. What do you have to know? What is a disclosure statement? So I'm going to say what is a disclosure statement. And the disclosure statement is made up of the table of contents, which is a guide to where the disclosure statement deals with some of the common areas of concern to purchasers. So in the table of contents, it will be included the declarant's name. Who's the declarant? Is the builder, is the developer. The builders can have a contract for the developer and the builder can be two different people. The developer is the owner of the project. The builder is the company that is going to build the project. So the developer will prepare this disclosure statement. And this disclosure statement will include the name of the declarant's developer, the municipal address, a legal description of the property, the address of the property, and the condominium corporation, the municipal address of the property proposed. Then, this is the disclosure statement, and this is, they are obliged to introduce in the package. There are rules of law, and then the disclosure statement will deal with. These are not all the disclosure statement, but the most important that you will find in the purchase package. It will be a disclosure of the corporation if it's a freehold corporation, if the property is or may be subjected to the New Home Warranties Plan Act, and then the box will be checked by the condominium, by the developer. Then there will be a disclosure if the common elements and the units are enrolled as well. And these are all the other statements that will be disclosed. Then I move. In the disclosure pack statement, you will find the table of contents, which I already showed, the date of disclosure documents, the name and municipal address, and you will have a general description of the project. You will have literally in the declaration, there will be a description of all the property, a description of the building, the parking, the storage units, the description of recreational and other amenities. Then there will be a marketing of block of units and a significant characteristic of the agreement. And the warning and notice clause. This is the declaration. So the declaration is executed according to the Condominium Act. And these are all the subtitles that you will find. Specific in the description of the property, you will find a specification of the common expenses. You will find occupation, use of common elements, ownership, occupation, these units, insurance, general matters. Then the declaration will have schedule. The first schedule is the description of the land. Second schedule will be consent of mortgage. Third schedule will be unit boundaries. And you will have boundaries of residential units, parking, storage. You will have a schedule D, common expenses, and a schedule E. The common expenses, you will have a grill, like you will have a breakdown of all the expenses for each unit. Then you have schedule E is the same. And then schedule F, you will have a certificate of an architect or an engineer. This is the declaration. And then you have a bylaws number 1, schedule to attach it to the declaration. This is what the bylaws will deal with. And there is a declaration, it will deal with the rules of the corporation, the corporation. So the register, the meetings of the managers, the board of directors or officer. In bylaw number 2, the bylaw number 2 will deal with the borrowing of money. So how the money can be borrowed by the corporation. You know that this declaration will be registered on title. When you know that they can start to sell the units, this is the declaration that has to be registered on title. And when it will be registered, the developer then will pass the ownership to the condominium corporation. And the condominium corporation will be made up of the owners of the single unit. So schedule 2, which you will have bylaw number 2. Schedule 4, you have bylaw number 3, that it will be between corporation, and they will deal with the relation between corporation and declarant. And then you have bylaw number 4 with the operating agreement. And then you will have a bylaw number 5, which will be a warranty agreement between the declarant and the corporation. Then you have the declaration, then at the end you have the rules of the corporation, the condominium corporation. And here you can find what your client may look at: the enjoyment, the security, the safety, the common expenses. And then at the end, you will have the tenants information form, which will be included in the original package. And then you will have the management agreement. The condo package, it's very complicated. It's made up of many things, but at the end you will have the year, annual budget, status certificate with preparing issues, liability insurance, indemnification. What you need to understand legally for you, because it's a package already prepared by the developer's lawyer. It's difficult that they will change. It's difficult that they will change their own rules or statement. So, but what you have to deal and you have to negotiate for your client, first of all, is the assignment. When your client, there should be a statement in the package that you cannot assign until a certain percentage of the condo units will be sold. Usually it's 85%, and you cannot put the condo on the market. So what do you want to negotiate right away for your buyer when he's going to sign a pre-construction agreement? That he can assign to another person before the closing date. He can give his rights and obligation to another buyer, a second buyer, and you will negotiate for sure the fees. Because the fees, the consent fees, because the builders will impose his consent, and there should be a fees to give the consent. Like when your client wants to assign his agreement, he has to ask a consent to the builder, and the consent to the builder from the builder will cost approximately between 15,000 to 30,000. So this is the step you will negotiate the consent fee, and this is the step when you can guarantee to your client an assignment, because most probably in the original package there is a statement that the condo cannot be assigned. So you will first negotiate that is assignable. If there is a statement that it can be assignable, you will negotiate the consent of the builder. You will never be able to read off the consent of the developer, but for sure you can manage the fees within 15 to 30,000, 5,000 to 30,000. You can just say the fee for the consent is approximately 3,000-4,000. Already you make a good impression to your client, because you are negotiating something for him in the pre-construction agreement. Then another thing is important. You have to negotiate at this step the lease. Most probably, when your client gets the occupancy date, it may stay 1 year, 1 year and a half. Renting is on place before there will be the final closing, so the final registration of this declaration. So what you want to be sure of, that your client has the right to lease the unit during the occupancy period, because the developers for sure will add, the developers for sure will add a clause that will add a clause that the unit cannot be leased during the occupancy. But your client may not want to move in, may want to lease, and with the lease may want to pay, and with the lease may want to pay the lease he may want to pay the occupancy fees. So you have to negotiate the right of your buyer to lease the unit during the occupancy period. And then you have to negotiate it. Most probably the builders, which I have been seeing lately, the developers will put a percentage of an additional deposit to lease the unit during the occupancy period. What you want to negotiate is first the right of the buyer to lease the condo unit during the occupancy, and when you want to negotiate eventually is to avoid an additional deposit. Then moving forward, this is approximately, and then what's the important thing is the cap. These 3 points can be negotiated by you. You don't need to have a lawyer interfere at this stage. You can negotiate these 3 important things. The cap, you will see a clause, you will see a paragraph in the agreement of purchase and sale or a schedule where it's a written statement of adjustment. When you see adjustment, there will be many statements dealing with levies, tax, with development charges. There are additional fees that will be charged at the date of the closing. You may want to just put a cap on it, like for example, the educational development fees. You want to put a cap between 5,000–6,000. Or for example, the tax, eventually, if your client has to pay additional fee for tax, you want to put a cap there. Please delete the levy fees. The levy fees is for lawyer. It's neither $100, but the developer has to pay his lawyer. Your client doesn't need to accept to pay levy fees. As well as what I have seen many times when there is when the check will be returned or for fees and everything, don't go for $250. Decrease the fees to $50 for check, for deposit, or whatever the fees to be paid to the developer. You have to decrease of $50. And these are the most important and common elements you will find in a pre-construction agreement. And then the pre-construction agreement, what you want to negotiate with your client, you know already. For the part regarding the deposit, the original deposit, your client has to provide 5% and has to provide a mortgage approval. You may want, if he's coming from abroad, he may not be able to provide a mortgage approval, but he can increase the initial deposit. Be careful when you do increase in the original deposit, because the 5% is covered by insurance. After the developer has to provide a private insurance for the additional money provided by your client as a deposit. So there should be a private insurance, and in the amendment agreement of purchase and sale, the developer has to write that he's providing an additional insurance for the additional deposit over the 5%. Sometimes you have people coming from abroad, investing money from abroad, and then they are not getting the mortgage approval right away. So to not lose the deal, instead of depositing the 5%, they will deposit the 20% of the project. They will the 20%. So they will give a deposit of the 20% of the purchase price. What you have to be sure that 15% will be insured as well. So if the project will not go through, if the project will be canceled or whatever, you have to be sure the money of your client is protected. These are the most important things for a pre-construction package, because it's like more showing to your client what the pre-construction package is made of, and then showing that these are the different documents. But on a negotiation level, it's very difficult. You will get different and more favorable clauses to your client because are standard. And this is the most important. So I repeat, be careful. The deposit, it's over 5%. You went to the insurance from the private insurance from the developer. The assignment is important. Your client may don't want to close, may want to sell his pre-construction agreement. So you have to be sure he has the right to sell it. The consent from the builders is a lower amount. And then for lease, and then third point, the lease of the unit during the occupancy period. There is a prohibition. The developer will prohibit everyone to lease the condo during the occupancy period. And then you want to be sure your client may don't want to move in and may want to make as an investment property, and he doesn't want to lose 1 year of money from his own pocket to pay occupancy fees. So these are the 3 important things. What you find in the disclosure package, I'm saying to you, annual budget for the first year, indemnification on the bylaws. Bylaws I show here they have different bylaws. When I went back and I show you what is made up, there's bylaws number 1, 2, 3, 4, 5. There's documents you will find again in the status certificate. Okay, so when I go in the status certificate, I will find these are the structure and the rules of the corporation. So then I go back to this one here. Okay, so this is okay. This is and then I'm just adding some information regarding what's going on with COVID during this period. So I'm going here and say, so you see, this is what we are finding in the status certificate. Again, the common expenses, the budget, you will find the budget for the previous year, because if it's not a pre-construction package, but it means it's always the document for the condo, you will find the budget for the current year. Then you have the reserve fund, and then you have document for the insurance as well. So when you get the status certificate, what is important for you? It's important for you to review first if the common expenses have been paid by the previous owner. So if I'm going to represent the seller, I'm going to represent the buyer, I have to be sure first, if I represent the seller, that I have as an agent the status certificate available for me, because the status certificate will be a condition in your agreement of purchase and sale. Who's going to buy wants to have a status certificate available within 5 business days from the execution of your agreement of purchase and sale. So they want to have these documents to see what is the status of the condo. First thing they will look at, common expenses. Why? Because they want to be sure they have been paid, there are no debts from the previous owner, from the sellers. So you will go here in the common expenses. You will see exact amount, and plus the common expenses will be adjusted in the statement of adjustment at the closing date. So if the seller has been paid, there will be a credit to him. If, for example, I'm selling the condo on March and the common expenses were paid in February and they have not been paid on March, the monthly common expenses of March will be credited to the new buyer. And then you want to be sure that everything for the past has been paid. So then I want to know the budget. I want to know the reserve fund. Why I want to know the reserve fund? Because I want to know if the condominium has enough money to make project renovation construction. Because it doesn't have enough money, the reserve fund has to be increased. And the first thing will be increased will be the common expenses. So when I review the status certificate, I say the first thing I see the common expenses. Then I look at the reserve fund. If the reserve funds are low, I understand exactly that the common expenses can be increased in the future years. And your client wants to be sure that the common expenses are approximately the same as the date they are purchasing the condo unit. Then what I would choose right away if there are litigation on file. Why? Because if there are litigation, first of all, the condominium, what is the status? So sometimes first of all, you have to be sure that the management is doing a good job. If there are many litigation, it means even the management is not acting properly. If there will be loss in this litigation, what will be added right away? The owner will have to increase the reserve fund, will have to increase the common expenses they have to pay the condominium in order to face the loss in the litigation. So when you see too many litigation outstanding against a corporation, walk away. Be careful, investigate, but try to walk away. So what's going on here? So practically, you will go here. Then we have these common expenses. And I'm going to understand it's not uncommon enough to focus on the current expenses of the condominium. The failure of a purchase lawyer to carefully consider entire status certificates. So it's important to review all status certificates, not only the common expenses. I told you what we usually try to review it. Then the purchase client must be advised that there are a variety of circumstances that may cause the condominium to change. I told you already what can change. If the reserve fund is low, if there are litigation, if there are renovation to be done, the common expenses can be increased drastically. Then you have to see the budget. So what is the budget? The budget is what the condominium, what the condominium has. So must condominium allowed, we're going to establish an annual budget. As a condominium corporation are not for profit organization, and the budget of a condominium corporation is not expected to be a result in deficit or surplus. If you see in the status certificate a deficit or surplus of the budget, it's not a good management of the company. So there is an alarm, a warning in the status certificate if you are representing the buyer. But even if you're representing the seller, you have to warn him what are the deficiencies in the status certificate. Then, after the approval of budget for the current fiscal year, they can be events that gave a surplus in the deficit. So, if a condominium corporation begins to incur excess costs during the fiscal year, you will have the condominium corporation may increase common expenses, is what we have been seeing right now. Then, so they will be prepared the reserve funds. It will be a reserve fund. It has to be that the condominium corporation only uses funds for the major repair and the replacement of the common expenses. The status certificate and the attachment should be reviewed to ensure the reserve fund studies have been completely in a timely manner, and the reserve fund has been funded in accordance with the current reserve fund study. So there will be reserve funds. They will be studied. Usually can be each year, can be in 5 years, can be sometimes 3-4 years. And the reserve funds will show how much funds has to be added to the final budget. If someone wants to interrupt me and just make a question on it, I don't want to go forward, and then maybe no one is following me. I prefer that all of you can interact. I'm seeing here there are 83 participants. I don't know if the 83 are following me, but have you ever came across to a status certificate? There is someone who wants to interact with me. I would like someone that started to ask me questions. I don't want to go forward until the end and no one has understood. So I don't mind. Someone has had problem with the status certificates and maybe the
okay, I think there's lots of people just keep listen. So a little bit fast, maybe you can slow down a little bit. And there's 2 parts of the presentation. First one is for the pre-construction agreement purchase sale, right?
Yes.
And is there any agent you have a question regarding the pre-construction, the agreement purchase sale?
It's a question.
Yes, I wanted to ask you a question. I wanted to know how basically easy it is to try to revise the contract and send it back to the builder, because the reality is sometimes getting the unit itself is challenging. So once you want to change anything, be it for the contract, the builder, they probably don't mind, and they, you know, give the unit to some other people because they don't necessarily have time to go ahead and revise. For example, let's say 250 expense, you want to change it to 50. If you get back to the builder, how possible it is and how easy it is for them to come back with what you really want.
Okay, so your client has 10 days for disclosure. So your client will sign the agreement, for example, January 28, and he has 10 days to review all the disclosure package. During these 10 days, the unit is locked. So the developer cannot sell the same units to someone else. So don't get scared that your client wants to negotiate something. It's absolutely true that the pre-construction agreement, the negotiation on the pre-construction agreement are very low because it's a standard agreement. And then if they are selling and they're going very fast, they don't want to change their standard rules. But there are certain things that are important because when you represent your client, you want to show your client, first, you want to make him happy and you want to be knowledgeable in front of him. So first you go through all these documents. I show you simply what does a disclosure pre-construction agreement is made up. And then 3 things are important. The statement, the adjustment, each developers lawyers will put a cap. I always saw that when there's educational development charges, there will be a cap on it. Instead, your client to be charged at the closing date, 15,000, he can be charged for 7,000, 6,000. So you want to put a cap of 6,000 or 7,000. Then there is levy charges, $65. Absolutely, it's ridiculous, but in front of the eyes of your client, it makes sense because you are negotiating a clause. And that levy charge has to be paid by the developer's lawyer, not by your client. So you want to, first, as I told you, in the adjustment, you want to put a cap for the educational development charges. Then you want to delete the levy charge. Then there are taxes charges, and you want to put another cap on it. Then you will see that there are other expenses that your client will be charged for it. Put cap. If you are not able to delete, and maybe you will not able, but you can put a cap, a maximum amount your client will pay at the closing date. These are the adjustment. This is the schedule for the adjustment. Then you have another 2 points you can negotiate. The negotiation is for the lease between the occupancy date and the closing date, because you're fully aware that in the pre-construction agreement, you may have time before arriving at the closing. The declaration that I show has to be registered on title. So before there will be the closing date, the client will be in possession of the units for 1 year, 1.5 years, 3 months, you don't know. In that time, and maybe your client doesn't want to move in, is using a condo unit as an investment. So he may want to lease it. So by leasing it, he can pay the occupancy fees each month. So there is a prohibition. The developers, the pre-construction agreement, for sure, there's a clause that you cannot lease the condo unit between the occupancy and the closing date. You want to be sure your client, the buyer, has the right to lease the condo unit. And then you want to be sure, first, because the developer lawyers can add the 2 clauses, 2 restrictions. One restriction is an additional deposit of 5% at the closing date, at the occupancy date. It means that for giving the right for your client to lease the unit between the time the occupancy to the closing, your client has to get this right. He has to pay an additional 5% of the purchase price at the occupancy cost, at the occupancy close. So at the occupancy, you want to cut off this additional deposit, and this is the lease. So your client is safe. If the occupancy will go through for 1 year, 1.5 years, he has the time and he has money to pay it. Then the third thing is important is the assignment. The assignment, there is a prohibition for sure in the developer contract that the unit cannot be assigned, or the unit can be assigned with the developer's consent. What you want to negotiate, and you can negotiate these things, are 3 few things, but 3 things that will make your buyers happy and you will show to be knowledgeable in front of your client. So the third thing, as I told you, is the assignment. It means that the buyers can sell this agreement in the future before the closing date. It means that as the buyers, they has to get the consent from the builders. So first, you get the right for the buyers to assign. Second, you want the consent from the developers. The consent from the developers to assign, to sell it, it has a cost. It can be between 5,000 to 30,000. You don't know, 5,000 to 15,000. You want to put a 2,000, 3,000. You want to decrease the builder's consent fee. Then you have another thing. There will be a condition that the condo can be assigned only if the developers will sell 85% of the condo unit. Don't be worried about it. You can try to negotiate. I'm sure you will not be able to negotiate, but if in the future you will provide the assignee, you will provide the developers with a new buyer, he will accept. And then another thing, you will have a condition that you cannot put the condo unit on MLS. If you cannot put on MLS, if you cannot put on MLS, okay, here I'm trying to go through many questions. And I like that you're making questions because I have experience in this and I prefer to interact and to understand where you had the problem for it. So Pari, am I correct? This was the question you were given. This was your question?
Yes, thank you.
So you understand 3 things you can negotiate: assignment, lease, adjustment. Then here I have another question. Okay, I answered Diana's question. Then I have Servin. What is considered as a reasonable assigned fee? Okay, what is considered a reasonable assigned fees? It's 5,000, 7,000. 7,000 is the average fees that I have been seeing. But what you want to decrease, you want to decrease as much as you can. You will start to say, no, you want to decrease 2,000, 3,000, try to decrease the consent fees because it will be the fees that your client will pay at the assignment fees. So if you want to do investment for a client and the client is going to buy in pre-construction and then he wants to assign, usually he can make 50,000, 70,000. I haven't seen lately even 75,000, 100,000, but usually the average has always been the buyers can sell his pre-construction agreement for 50,000. For 50, he will make a profit of 50,000. If the consent fee is too high, guys, it's 15,000, your client will make 35,000 of profits. Then he has to deduct HST, tax and everything. It was not a good investment. So try to decrease the builder's consent fee lower than that, 4,000, 3,000, 4,000, no more. Then I go with other question. So am I correct, Sir Finn? Can you answer? Are you able to answer me? Then I have a question from Alex. The major difference from the new policy, the old one for realtors, in what sense? Can you explain to me, Alex, can you explain to me your question? Can you unmute?
No, yeah, sorry, I just unmuted. Sorry about that. What I tried to ask you is, for the realtor, right, us, we don't have that much time to know all of those details, but it's all come back to your lawyers for sure. But on the site, we want, because lots of our buyers may ask us, what's the difference? I heard the new policy. So give us the 3 highlights we need to learn, we need to know, and we can easily explain to the buyers to persuade them to buy. So that's the question for you. So we don't have that much time to know all of the details, right? We don't even know what's the difference between. So, but you know, buyers always ask you some question. Just quickly get 3 difference as the highlights. We can easily to use it and remember it.
You have my presentation. It's easily to show you what you find in pre-construction agreement. That I will appreciate if Sammy would give it to all of you. When you go for a pre-construction agreement, it's done for this reason. You just bring with you And when you show to your client, you show what the reconstruction agreement is made of, why he wants to look at it, and you are the realtor, so you will show him the measurement, the measures. You will show the upgrades. You will show him what will be the unit in the future and the price. What legally you have to see with him is I told you, the adjustment, the assignment, and the lease, because these are the only things you can negotiate with the developer's lawyer. It's difficult, you will negotiate other things, but this is where you have to concentrate your attention on it.
Sorry, I actually remember another question. You talked about briefly about the insurance on the deposit. Is there a specific clause we can refer to find out, just in case the project gets canceled, the purchaser can actually get back the deposit? Where is the clause we can look for to make sure the deposit is in type insurance?
In each agreement, I don't know where they are writing. Each agreement is different, but the 5% is insured. After, no, you have to ask when you are at the site, you will ask the representative to be sure the additional deposit will be insured. So then there will be the developer's lawyer will prepare an amendment, okay? And in the amendment, you have to see that you don't prepare anything. It's the developer's lawyer will prepare for your client. So in the developer's lawyer's amendment, you have to ask the representative at the site that a private insurance will be added for the additional deposit. You just ask them at the site, and the representative will refer to the developer's lawyer, and the developer's lawyer will prepare for it. It's a rule, and you will ask. You just have to ask, because I don't know in the single agreement where they are going to write it. That has to be included in each pre-construction agreement, the option for a private insurance. Because when you put an additional deposit, the developer's lawyer has to provide you with an amendment, because the standard contracts are just for the 5%, are not for the deposit. So they will prepare an amendment to the original agreement of purchase and sale, and your client has to sign. In this amendment, which is one page, just one statement that he's adding an additional deposit and the breakdown. At that time, you have to be sure there's this clause that the developers will add an insurance policy for the additional deposit. Did I reply to your question?
Yes, but your voice kept on getting disconnected, unfortunately.
Okay, no, ask me. I'm here for you. I prefer to interact because I have been done a lot of this, so I prefer to interact. When the buyers will ask to add additional deposit, the standard format will request 5% and mortgage and the financing approval, okay? This is the standard agreement. If your client cannot provide the mortgage approval because it's from abroad, he will be required to increase the additional deposit. It can be increased until 20%, okay? So the original agreement has to be amended. The developer's lawyer has to prepare an amendment statement, just one page, half of a page, where you will see that the original deposit will be increased from 5% to a percentage. And then there you will see a breakdown of the payment for the additional deposit, and you have to see a clause there. The clause that the developers will provide a private insurance for the additional deposit. Okay.
Yes. Okay. Yes. That's actually for international buyers if they have to.
No, not only. Yeah, usually investor from abroad. The people cannot provide. Well, if someone cannot provide a mortgage, a financing approval, he can just increase the percentage. This is the rule.
So, for example, if the project is already asking for only 15% down, would they have to be a clause in the purchase agreement to make sure that the deposit that they're gonna be paying is already insured, just for the local buyers, not for international?
5% is insurance. The additional to 5% has to be insurance. If the 5% is insured already. The additional one is not insured. So you have to be sure that it is insured.
Okay. So you mean that whatever deposit we see for all these projects already have the insurance on it. You're only talking about the 5% that's supposed to be paid at the time of the occupancy.
No, I'm not saying this. The agreement of purchase and sale requests a 5% down payment, okay? Whatever is up to 5%, you have to get, the developers has to give another insurance. Purchase price is $500,000. I'm at the pre-construction site. I'm just buying now. I'm buying at the first stage, okay? And I agree to pay all the 5% down payment, and I agree to break down the payment, and I may agree to ask to deposit an additional amount of money at the occupancy date. What is up to the 5%, you have to be sure there is a clause in the amendment of your agreement of purchase and sale that is also insured.
Okay, got it.
Whatever stage you are, Pari, am I correct?
Yes.
Okay, whatever is the additional amount of money they are paying, you have to be sure is insured.
Okay, but we also can negotiate that the buyer, if they decide to assign, they don't have to pay that 5% at the time of occupancy.
No, the 5% is not at the time of the occupancy. The 5% is during the pre-construction period, before the occupancy. There will be a breakdown, right? You will break down the amount of money that you have to pay. If you can, the problem for additional deposit starts when people cannot provide mortgage approval. When they cannot provide that they can pay the full amount of the closing, the criteria is to ask if they can provide right now an additional deposit. And they may ask 20% of the additional deposit. Happen to clients of mine. Instead of giving the 5% a certain percentage, they give more additional deposit. But the additional deposit is paid during the period, not only at the occupancy. Depends on what the negotiation you have with the developers at the beginning. So you are not paying the down payment at all. You may pay the down payment deposit during the time. You don't need to pay. Maybe you want to pay zero at the occupancy date. You don't know. But remember one thing: when you arrive at the occupancy date, and you let me remember one thing. When you arrive at the occupancy date, am I correct, Pari? I don't want to confuse it with another thing I'm going to tell you.
No. Yes, I'm listening. Yes.
You don't have a mortgage approval, you go for an additional deposit of what is requested in the original pre-construction agreement. This is a private negotiation between buyers and developer. The developer's lawyer will prepare an amendment, another page, a different page to be added to the original agreement. When the party negotiate an additional deposit and the mortgage approval will not be provided. On that additional deposit, be sure there is insurance from the builder, so from the developer. So something happened to the project, your client's money is covered. Another problem, people have cash. So happen that there is a clause that you may want to negotiate in the pre-construction agreement. The clause you want to negotiate is that you can increase the deposit at the occupancy date. Why? If I am a buyer and I buy a condo at the 4th floor, and it's a building of 55 floors, for sure my closing will not happen right away. The occupancy cost for the 1 year, 2 years of occupancy will be calculated. One part of it will be calculated as an interest on the final amount that the buyer has to pay. So if I have to pay $2 million in 2 years, the interest that I'm going to pay monthly as an occupancy fee will be very high. So what you want to negotiate with the developer's lawyer is that your client can increase the deposit at the occupancy date. It means that if I'm a buyer and I'm seeing the building is almost done, and even if I'm going to occupy in January, by May, June, I will have the closing date, it's fine. But if I'm going to occupy in January and my closing date will be in 2 years and I owe $2 million, my occupancy would be crazy. Why do I have to lose money and I have cash. So at this point, I prefer to increase the occupancy, the deposit at the occupancy date. Is that clear?
Yes, yes. That actually, I didn't know that you have the power to negotiate such things, because at that time, everything is said and done. I was always thinking they probably don't even want to show any flexibility regarding that, because they already paying interest themselves on the construction loan. So,
And maybe your client wants to save money. So be careful that for the pre-construction agreement, you can negotiate these things. Are little things, but first of all, can protect your client's money and show in front of your clients that you are knowledgeable in your field. Okay.
thank you.
Then I'm seeing here, there's another question that if I can cap, okay, the levy charge, it's $65. So it's just to show to your client what is it, but it's ridiculous that the developers are charging the client. Then what I have been seeing lately in some pre-construction agreement, they put a cap like 15,000 a general cap. But I have, honestly, I saw only one time. Always they put a cap for each thing. So you cannot put a cap of 10,000, that's it. You will have to go through each statement. There is a part. Usually you find in the agreement of purchase and sale, inside the agreement of purchase and sale, you will find a chapter, only adjustment, or sometimes you find as an external schedule attached to the agreement. And this schedule, you find different adjustments. You got to go through with your client. The educational development fees can arrive to 15,000. You can go down for 6-7, but you cannot have a cap of 10,000 for each adjustment. It's difficult that the developer will give you. Happened that time, I saw it just because the buyers knew the developer. So they were negotiating between themselves and he made a favor. But for the rest, you have to put a cap, a maximum amount your client can pay for each single voice. So if educational costs are some, realty tax is something else, fees for meters or for other stuff. So you will go one per one. Okay, someone is asking me standard range of reserve funds. I'll be honest, you cannot have a standard range because it depends on the building. Depends on the building, depends what the building is, what depends on the building. It's related to the type of building. If it's a simple one, 6 floors, 7 floors, and it's a lower reserve funds of lower than 1 million, it's a good one. But if your building, it's made up of 54 floors, you want to have a higher reserve fund. So you have to be sure that it's not a standard one. It's related to the type of condominium. I cannot answer a question like that because the only answer I can give to you, it depends on the type of condominium you are dealing with. But I can tell you that usually what I look at the budget. This is what I look. I look at the budget and I see if it's over 1 million. When it's over 1 million, 1.5 million, then I started to accept the status certificate. And then I go for, and I started to accept the status certificate. If it's lower, few 100,000, no, because you just need one renovation, and just one renovation will increase your client a monthly amount for common expenses for sure. So, and then sometimes I haven't seen, for example, I saw good budget without reserve fund studies for years, and I don't care at this point because the budget is good. But I haven't seen as well that there are budgets on the average like 1 million, 1.5 million, and there is no reserve fund study. But if you see in the status certificate, there is a study on the reserve funds, that one is important. First, because it's showing you that there is a good management. So they are working correctly and properly. They are trying to deliver. And what you want to see is that they are trying to deliver it. And what you want to see is that according to the reserve fund study, you can understand if the budget will be increased dramatically or not. Did I answer, Helen, to your question? Helen? Perfect. Someone
Oh,
else.
yes, thank you.
Okay, so there is not a fixed standard or like a fixed number. Okay, so there is some other question? I want to finish the presentation, but I want to answer all the questions that are important, because your question helped me to come up with other stuff that maybe I don't remember, and I went through the different case. So we went through the, okay. Okay, so the common element fees are, they are, yes, for sure, the common element fees. Usually the common, what do you pay with the common element? You with the common expenses, you will pay the expenses on the common element, whatever is in the building. So they estimate what can be as well. It depends from building to building. If it's a small building, or it's 2 towers building, or it's 1 tower. But what you're going to do is just you are going to estimate what are the usually expenses for the building, from the property manager, for the cleaning, for everything, and then you distribute, you share as a percentage according to the ownership of the owner. It's a building of 45 units and you have 45 owners. You will consider, for example, the expenses yearly will be 100,000, for example. I'm just saying it's too much. You will divide the 100,000 not for 45 owners at all. You will divide $100,000, which is expenses, the yearly expenses for common element. You will divide it per percentage of ownership. My condo can be bigger than your condo, so the these expenses will be breakdown, will be divided according to my percentage of ownership in the total condominium. So if I have a condo of 2,000 square feet, I will pay for sure a higher amount of common expenses, and it will be calculated on the percentage of my ownership in considered to the other. Like there is a 45 unit, okay, there's a building, 45 units. I have 45 owners, but total can be 100,000 square feet. I will divide the 100,000 square feet per each owner, and the common element will be considered according to the percentage of the ownership. Am I correct? I know, because I did this. It's admin. Okay, so the expenses on the common element will be divided according to the percentage of ownership. And it's a very complicated calculation, but you will find in the disclosure package, you will find a chapter where you see the percentage, the division of the the breakdown of the percentage ownership percentage for condo, for the unit 1, 2, 3, 4, like 45 units. You will see a 2, 3, 4 pages where you will find 45 units, and there is the owner's percentage, and then you will see the owner's percentage, ownership percentage, and then you will see the percentage of the expenses. And then according to that percentage, it will be calculated the common expenses. Why you want to increase the common expenses? You want to increase the common expenses if the insurance is becoming higher. For example, lately with COVID, this is what I want to say. There are increases in the insurance premiums, cleaning costs with COVID. I think the common expenses will be higher right now because there are cleaning costs, a lot of cleaning costs, increasing cleaning costs. Then there are legal fees in the other matter. These are the example that can increase the common expenses. And this is what's happening right now with COVID. This is the reserve funds, the insurance. What I don't want to lose, because I saw that we are almost 12. I don't want to lose to let you know that there are new rules in the condominium corporation due to COVID. And the real news are due to the restriction access to visitors. There are closing restrictions of certain amenity areas. You know, the gym are not working, the swimming pool as well. But there are other limiting, the type and number of renovation, that can be go inside the unit. There are certain condo, the renovation, if it's not an urgency, you want to renovate your units in this period, that there is a limitation on it. Just about the insurance. Okay, here again for the insurance, you just at the site when there is a representative, I don't want to confuse you. You want to just protect your client's deposit at the site when there is a representative and there will be an additional deposit, Joanne, you just ask the representative to add a clause that the developer will provide a private insurance for it. And there will be in the amendment. These are the rules, but you want to be sure the additional deposit is covered as well. Joanne, am I correct? Joanne, did I answer? Ask me other question. I'm here to. Okay.
Yes, I have another question about the resale condominium. Let's say 10 years old, and then when you read this status certificate and the budget, and how you judge if the reserve fund is healthy or not healthy versus the budget, and because there may not be the study engineering or consultant study report available at the time.
Okay, so what I look the budget. Okay, I look at what is in the budget now. I look at what is if it's 1 million or 1.5 million. Look, sometimes I can tell you I have been seeing status certificate for all the condominium doing very well, and then if this budget is high, 2 million, 3 million. I don't care, honestly, I don't care a lot on the reserve funds study. But if the budget is low, it's all lower than 1 million, I personally, it's not a general rule, is what I do. If it's lower than 1 million, I go to see if there is a reserve funds study. And I'm going to see what is their plan. If there is not a plan, I will advise the client and I will give my opinion. That in general, they can, and I have to see if there is not a reserve fund study, I have to see if there are projects for renovation. But the problem is that when you buy a condo, you buy the condo as of today. So maybe next week, there will be renovation project. So there is a risk. So when you don't see a high budget and you don't see a reserve fund study, you will advise your client, you will tell them that they may incur in additional expenses which you are not aware of, but it can happen, it potentially can happen. When you see a high budget amount yearly, you know that your client is not going to pay additional common expenses in the short period. And you will advise in this way, you will tell them that the budget is high, and then you honestly, you will see that there is a certain amount of money the condominium, the condominium corporation can manage. And so your client will not, this is the problem. The reserve funds of the budget will be, is linked with the common expenses. When you have a higher amount of money, you don't care that your client will pay higher common expenses. Where you don't have a high amount of money in reserve funds, you will go and see if there is a reserve funds study. If there is not, you advise simply your client. There are healthy management and not healthy management. This is not up to you. You can just, look, I haven't seen client buying property with a very bad status certificate just because they loved the unit. They loved where we're located. They loved the location, that they thought that they can make money. So they really didn't care about the status certificate. They didn't care neither that there were many litigation against the corporation, because they were thinking that in 6 months, 7 months, they will be able to pay back. But you just advise the client. You just advise the client, and then the client will make their decision. Joanne? Well,
and thank you. That's very good. And that one more just extension. So is there a rule of thumb? What percentage of the budget should go to the reserve fund?
In what sense? In what sense?
what percentage of this kind of fee and collected and should go to reserve fund? Is there like a rule of thumb, like a 20% go to the reserve fund, or is there any such a thing?
Yeah, but this is a condominium to condominium, and they change. There is not a general rules for it. It changes. A percentage should go to reserve funds. A small percentage, yes, it's going. 1% is going to pay out to the common elements, and another percentage for sure is going for the reserve funds and for the budget.
Thank you very much.
Is your client asking all these things?
No, myself is also investor, so I'm looking for that detail.
There are other questions that you may want to ask me, like usually, honestly, when I go through a pre-construction agreement, I enjoy to read all of it, but these are the negotiation, the opportunity to negotiate are very low, but it's very interesting as well. And you can easily, in this period, you can easily use it for investment purpose. I haven't seen, honestly, I saw many agents having troubles in find inventory in the market, but with the pre-construction agreement, they can easily buy 6, 8, 10 for the investors because they know that they will sell soon. So they can just stop, invest the money there, and they can play with the assignment moving forward in 6 months, 1 year. For this reason, I always tell you, be careful when you buy pre-construction. Be sure that there are. Okay. In the presentation I gave you is a presentation, the first part. The second part that I appreciate if Sammy will give to you. It's just to let you know what you can find as status certificate. The first part of my presentation includes the description, a breakdown of the document that you find. As I told you, assignment, you want to negotiate assignment, this and this. So useful tips for condo are these things. You want to negotiate in front of the client the assignment, the lease, and the adjustment, and you want to play with your client's money for assignment. You really want to play with it in this market because you don't want your client as an investor to pay a house which is worth 500,000 to 700,000-800,000 because tomorrow in the market you don't know what can happen. But for a pre-construction, you will not go wrong because your client is investing money right now and he can sell later on. So ask me other questions, guys. I don't know if you have done a lot of pre-construction agreement. I don't know if you have done a lot of assignment, a lot of condos purchase agreement. I'm available for each question. You are 75 participants. So I think you have a lot of experience on it. Am I correct?
Yes. So I just get some agent ask yesterday, they ask how many times the pre-construction can do the assignment, because yesterday I have an agent, they ask me, said that this is the second time for the assignment. That means assigner is basically assignee from another assigner.
You don't have a limit. You don't have a limit. The only thing with the assignment that you have to be careful is the prohibition in the regional pre-construction agreement. The prohibition in the construction agreement regarding the client that he needs the consent of the developers, and until the developers will sell 85, usually the condition is that the 85% of the condo should be sold before an assignment can take place. So this is the clause you have to deal with, but the rest, you don't care, neither the developers care. So in fact, the developers wrote a clause that the new buyers he will not be responsible for HST rebate for new buyers because he doesn't know how many assignments can be done down the road. So don't worry about the number. There is no limit.
Okay. Can you talk about a little bit more about the portal? Because we recently, there's lots of the portal townhouse is a freehold townhouse, but they have a portal a partial of title land, just with a very less maintenance fee. Usually it's under $100. Can you talk about a little better about the portal, freehold portal?
I don't understand your question.
I think it's the part of tied land. It's a parcel of tied land.
A partial of tied land.
Okay, so you're a partial of title land?
Yeah, so maybe let's ask the first question. So if there is a portal, it's a freehold townhouse, but deal with the portal area, it's a common element area. So is the status certificate is mandatory on closing or not?
Okay, so if there is a condominium there, yes, the status certificate is, you have to provide the status certificate. Okay, parcel of title land. Yeah, you have to provide.
Mm-hmm. Okay.
When there is condominium, you have to provide the status certificate. You should have a condominium document.
Okay.
Is this the question that you wanted to know about it?
Yeah. And another question is, I was asked by our agent. They said it's a freehold townhouse, but with a portal, and the builder already gave the occupancy date. So is this the same as like a condominium? They have a final closing date, or the occupancy date?
No, depends. Depends. Usually is depends the project. Depends the project. If it's a few houses, when you start with the condominium, okay, the condominium is when you have a corporation that is managing all the townhouse or the house is in the project, okay. So when it's in this case, you always have status certificate and the common expenses and everything. But they can break down. They can have a project and they can break down as well. They can break down and they can go one per one. But if there is a component, is the project and they are selling all together, yes, there will be again occupancy, there will be again closing, and they have to wait until the closing for each one. It's how the developer will manage his project. Like for example, if I represent a developer for 2 condo building, okay, I can have one condo building that will be closed right away, and I don't have to wait for the second condo building. Is how they manage it. But when there is and this is the problem, there will be a different declaration, and there will be different condominium rules for each project. It's the same as for townhouse and everything.
Okay, great.
Okay, so I have here a question. This is the tyrant warranty. So in the agreement, original agreement, you already have the date, okay? In the pre-construction agreement, you have to have a schedule, tyrant warranty schedule, okay? In the tyrant warranty schedule, they already inserted the different date for the closing, for the occupancy. So there is an extension as well. Then there is a date, it's the final date. You will see in the schedule to the original pre-construction agreement, you will see a final date, and that date should say firm date. If they go over the firm date, your client has the right to get back his deposit and ask for damages, or eventually can enforce his contract, so he may want to have it, and then have back the compensation. So he can ask some money for damages if the builder is going out of the date. But there is not you will find in the schedule attached to the pre-construction agreement. You will find the occupancy date, and you will find a tentative date of closing. But then there will be a firm date. And when there's a firm date, he has to respect it. Alice?
Hi, yeah, I have a case that one of my friend, it's not my case, but I heard one of my friend just purchased a townhouse, but after the firm date, the developer set a time range. So within this time, she can ask for the deposit refund. But after that, she cannot. So is that restriction or is that law go against with this clause?
Is a clause that even if it's not after she cannot refund, she cannot get to the compensation.
The developer just set a time range. Say if with the 60 days you can ask for the deposit refund, but after that you cannot. You have to keep as is, because the land is.
They give an opportunity for her to ask.
Yeah, but after the, I mean, if the purchaser cannot where with only with the 6 days they can ask for the refund. After 6 days they cannot ask for the money back, right?
It's negotiable. Okay, there are negotiations between the parties, contracts. I saw even in assignment agreement these things you are telling me. I saw lately in an assignment agreement that the developer asked the new buyer to renounce to the compensation. So the developer is asking them in an email. It's not an imposition. She can accept or not. It's up to her. But the developer ask her to ask a refund in 60 days. Otherwise, he has to know what he has to do with the condo. If he has to take it back, whatever is her position. So he gave her a window of 60 days to ask a refund or to move forward with the closing. This is what he has been asking. If she accepts, she has 60 days to ask the refund. You have to see what is in the pre-construction agreement as well, huh? Because I'm seeing there are different clauses. You have to see what is in the construction agreement as well. What was the clause related to this? If he never talked about it, and then he went over the 60 days, he went over the firm. Is it for the closing or is it for occupancy? It's for the closing or for occupancy? Alice, what is your client talking about?
The land is just there's no developer at all. So the land as is the 3 years before they purchased. 3 years ago, they purchased the pre-construction townhouse. So they didn't do, they do nothing with the land. I think maybe the developer has some financial problem. And when my friend asked for the deposit refund, the lawyer didn't reply her at all. Yeah, and they want, I think maybe they want to just put the date delay until after the 60 days. Right?
Well, they want to they want to play smart. They want to play smart with your client, with your friends. They want to play smart that they want to put a window that she can ask a refund or not. But I don't know the status of the project. So she has to see what is the status of what's going on there. She has to take more information to decide if she wants a refund or not. But in reality, they are just giving her a window. They are trying to protect themselves.
Yes, agree.
They are trying to protect themselves. So they just send an email and say, okay, in 60 days, you have to tell me what do you want.
Yes, yes.
So she doesn't have to reply. Then she makes on a decision, but I will not reply to the team.
I mean, the developer lawyer didn't reply.
So okay. Yeah. She asked for a refund.
Yes, but the lawyer never responds.
Okay, so she asked for a refund already.
Yes. And
okay, I misunderstood your question, sorry.
Yeah, the lawyer never responds, and then the time passed for 60 days, and
but she has. Okay,
yeah, she has all the emails. She keep all the records, everything. So she has to find another lawyer and negotiate with the developer lawyer, and yeah, that's another story. But
yeah, so she has to go for litigation. Yeah. How much money she deposited?
It's 100,000.
So she has to go for litigation, everything.
Yeah, it's a 1 million townhouse. Several years ago.
So he may have the problem. So that one is a litigation, but they cannot say, give me 60 days or not. However, your friend replied correctly. She wants the money back.
Yeah.
But they may have other type of problem, at least there. Maybe they are canceling the project or not, or they are transferring the ownership of the project to another developer.
Yeah, I agree. I do the research for the developer. They made up another phrase. Maybe they transfer the deed to another developer or something.
I think they are transferring to another developer. So for this reason that they were asking her for 60 days, give me an answer, because they are transferring to someone else. And they want to know what is their status and situation, but not because it's a deadline. A problem would be with your friend if they are going to transfer the project and they are going to shut down their company. It's a corporation, so you have to see if the corporation can refund it, and that whatever is there involved. But I don't know the percentage of the deposit from your friends as well.
Okay, all right, thank you.
Hello.
Yes.
Okay, my name's Jada. I have a question. Is, you know, we have been talking about all the condos and townhome. What about, like, you know, single detached pre-construction home? So basically, like, you know, I recently have a client, and we just try to thinking to deal with that developer, and they send me all their purchase agreement. It's a lot of document. It's like over 30 pages something. So this is my first time to deal with the pre-construction, and how should, you know, what should I be careful, and how should I do it on my side, and what is maybe the best way to find some lawyer who are experienced with this? What's your recommendation?
I personally, first I will show to the client that you are aware of what is inside the pre-construction package. Okay. Yes, for sure. I will always add a legal opinion from a lawyer, because whatever type of package is a townhouse, is a freehold, whatever, it's a condo, there are a lot of legal implications. So you want to have a lawyer to review it. This one you always advise. And your client has always 10 days to do it, to get a legal opinion on it. So always have your lawyer, someone you know that has expertise on it, that can review fast. My agent come, they ask me right away, they want to review an agreement. It costs nothing to review it, to be honest. Then the client will stay with us until the end of the closing. So I personally will always prefer that the lawyer review it. But at this first step, you have to show to your client as well that you are knowledgeable. So you know what is inside, because you are going with them to see it, and you will be the first person that will review with them at the site. Am I correct?
Yeah.
So you have to show them you know what they are talking about. So as well, the pre-construction package is always the same. What they are changing are the legal rules, are the numbers, but the structure of the package have to be approximately the same. So if it's a townhouse your client is going to purchase,
no, detached.
What do you have to be careful about it? Because happened to a few clients of mine, the customized one. You have to be scared. You have to be careful on the customized one and the cap for the price. Because I saw one of my friends, she was buying a customized one, and then at the end, the developer came up with a very huge amount of price. The price was incredible, was ridiculous, and they are in litigation now. And they are not in litigation because the price was shocking. It was higher than expected. So you have to be sure, you have to be careful in the detached. The condo is there. The price cannot surprise you. That one is the range. But for the detached, the other stuff, you have to be careful on the upgrades. You have to be careful on the margin. You have to be careful on the measurements of the home and everything. That one you have to focus your attention. Jada, am I correct?
Yeah. So basically, is right now the contract is just say, okay, you basically sign signed for this project, and then they give you like maybe 5 days or 10 days grace period. You discuss with the builder, so the builder and you like customize what you really wanted for, you know, the part. If
I can custom, Jada, I can customize the legal part, the number I told you, the legal clause. What you is important, you customize with your client, and this is your job. It's just the measurements, the type, what I'm for the detached. I had a client who bought the detached as an investment lately, 4-5 agreement, and then he wanted to change part in the detached house. Like they want an entrance in a different way. They made some changes. So when they made some changes, what the developer usually, the clause that they use it is that they will not, the clause they use it is that they will try to do it, but they don't assume the responsibility, and the buyers will always complete his closing, even if this work will not be done. But you have to put a cap as well. Like for building something else in the detached, the price will not be over, I don't know, it depends on what you wanted, 20,000, 50,000, 100,000. Like be careful on that. I saw with a client that, and then I saw with other clients that are in litigation. So Jada, this is your job. What other features that they may want inside the detached? They may want to, they don't want a wall. They want to have one bedroom, a large bedroom, and they don't want 2 bedrooms together.
Yeah, there's quite a bit of details they want to, you know, customize. So they said like after we sign this, then basically it's another brokerage involved. They are represented as their salesperson. So that brokerage has been like communicate with me is they are signing, we had to sign this first, then there's like 5 days grace period. We will discuss with the builder like to what the customize is going to be and how much that will cost.
Not true, Jada, not true. You can have 10 days grace period. Okay, general, you have 10 days. You have to ask for 10 days. If they change your number, it has to be 10 days. And then it's not true what they are telling you. You have to be sure your client has everything in front of her eyes at the closing of the contract, because maybe your client doesn't want the detached in the way is it. So you have to tell the developers that your client will buy, but the 2 contract has to be signed together. Don't let your client be involved in a contract and then she wants other things. Talk with your client to see if she agrees eventually to have the detached as is it in the status that she's finding. And if it's not possible, it's fine, because you may want to sign the 2 agreements together.
Mm-hmm. So
or put an extension in the grace period. You can ask an extension, say, you know what, my client will not buy if there are not these changes. So we can extend the grace period. Instead of 10 days, we put 20 days, and then you provide us the second contract. You want to know the price. There will be high amount of money to be paid for that changes.
Okay. Is that a good, like, we have a lawyer involved at this moment before we sign anything?
Always, I advise you, Jada, always. You don't know what you can find in the agreement. Lately, for example, I saw lately the agreement are more customized than what you think. Like until last year, I saw very standard agreement, but lately in the new construction, pre-construction, I haven't seen that they are very customized, more customized. There are problems with tree, there are problems with noise. So they're different than before. They are less standard than before.
Okay.
So I always will involve a lawyer at this stage, always.
Okay. All
the
right.
client then will remain with the lawyer to buy for the final occupancy, for the final closing. It's not a problem. It's not a problem for the lawyer to review it. I don't know what will be the fees for other lawyer, but usually what we do, we always review, and then the client stays with us for occupancy, for closing, takes time, or for assignment. What is your job? Be careful to the customized one. This is your job.
All right, thank you for your recommendation.
I saw, because one good client of mine is in litigation for $1 million because they promised to give customized one was 1.5. They come up with 2.3, 2.4. So be careful. Honestly, sometimes they play crazy.
Wow, how could we avoid those kind of, if they are
cap,
not
a maximum? You have to put the cap. Like these amount, you know that to change a desk or to change a wall, the average amount of money is, for example, a certain amount. So put a cap. A maximum amount of money the client will pay for it is this.
Okay. Thank you.
Nothing. I'm available whenever you want to ask, not a problem.
Okay, Katrina, it's already 12:30. Thank you for do the presentation 1.5 hours. And if you you know, maybe we can, if I have a chance, we get another presentation later time.
I'm more than happy. And then I have to thank you for the presentation. I'll be honest, you were so kind. You already gave me the opportunity right away. So, and I enjoy working with the agent, and I really enjoy like go through all this legal stuff. So it's my job.
Okay.
I have to thank you.
Yeah. Thank you for your time.
Bye.
Yeah. Bye-bye.